Hey guys, Dark Angel here. Hey, I got a good one for you today. Here's a little something for all you travelers out there to add to your arsenal. So there's a case that comes out 2000. Reno versus Condon, United States Supreme Court, 528 U.S. 141, 2000. Okay? I'm just going to get right off into it because this is a really short case, so this should be a pretty good short video. But like I said, this is the video. Okay, or this is the case, I should say, not the video. This is the case, because this case here is gonna kind of put a damper on a lot of the police officers' moods. So okay, so listen to what I say right here in this first paragraph very carefully. Okay, Congress may regulate states' activities using its Commerce Clause powers, provided that the regulation does not require the state to enact any laws or regulations and does not require state officials to assist in the enforcement of federal statutes regulating private individuals. Did you hear that? Did you get that? That's the rule of law. Facts. In 1994, Congress passed the Driver's Privacy Protection Act, DPPA, to regulate the disclosure of personal information retained by the state departments of motor vehicles, DMVs. Congress passed this legislation because states routinely obtain significant personal information from individuals in connection with those individuals obtaining driver's license and then sold that information to private entities at a profit for the state. Fourth Amendment violation right there, right to privacy, driver's license, no good. But wait till you hear the good part. Wait till you hear the actual good part. The private entities could also further resell this information. The DPPA was designed to prohibit the selling or reselling of individuals' personal information by DMVs or private entities without obtaining the individual's consent. South Carolina and its Attorney General Condon, plaintiff, brought suit against the United States government and its Attorney General Reno, defendant in the United States District Court for the District of South Carolina, alleging that the DPPA violated the 10th and 11th Amendments of the Constitution. The District Court granted summary judgment for Condon, and the Court of Appeals affirmed. Reno appealed to the United States Supreme Court. Issue: may Congress use its Commerce Clause powers to regulate a state's use of its citizens' personal information? Holding and reasoning, Rehnquist. I know you guys remember Supreme Court Justice Rehnquist. Well, yeah, this is what he said. Yes, personal information collected from individuals by DMVs is an article of commerce. Now, if you don't know what commerce means, look it up. It means to do business, do trade. Okay? So anything dealing with the DMV is commerce. It's business. Of course, we all know that already. But here it is in writing, and this is a 2000 case, y'all. 2000. So it's right there in black and white. 2000. The case is in reference to commerce, anything dealing with the DMV. Okay, so if you're not driving in commerce, the only thing the state can regulate is its commerce and its business. Okay, and if you're traveling like we do without a license, the courts have no jurisdiction. That argument is solid. It's just been justified and verified by the Supreme Court. Now, all you haters out there, all you constitutional traitors out there, get with that, because you keep wanting to cite that Hendricks versus Maryland case, but what you failed to do was read the entire case in its entirety, that case is actually in reference to commerce as well, as they could not prove one way or the other as to whether or not the young man was using his automobile in that of commerce, but the fees and prices that were attached to the license registration and everything would not affect the movement of commerce. And even though you keep wanting to argue, well, it says automobiles and anyone working in commerce, they're talking about the vehicles that do work in commerce and automobiles that work in commerce. So once you learn to discern the difference as to how that case is actually read, that case was really about the fees. It had nothing really to do about license and registration or any of that. So you guys can knock that off. But here's a 2000 case that supersedes that. And there's another case, Sinez versus, I'll look into it, but it's Sinez case that supersedes that case too. Okay? So, but anyway, back to this, because like I said, I don't want this video to get long. However, to be constitutional, Congress's regulations must not run afoul of the 10th Amendment as demonstrated by the court's decisions in New York versus United States 505 U.S. 144 1992 and Prince with the Z on the end versus United States 521 U.S. 898 1997. The present case is controlled more by its decision in South Carolina versus Baker 485 U.S. 505 1988 than New York or Prince, as Congress was merely seeking to regulate state activity and not the state's regulations of private actors or the actions of state officials. Congress has the power under the Constitution to regulate state activity. This case does not present the same concerns about Congress commandeering states' legislative processes or state officials' actions as in New York or Prince. And finally, South Carolina's argument that Congress cannot regulate state activity without making general regulations applicable to private entities is rejected. Basically what they're saying there is you can make this available to everyone on a voluntary basis. The underlying words that you're not hearing in there, you can make it applicable to anyone, anybody and everyone who wants to voluntarily register their vehicle, license their vehicle. Then that's a voluntary act, not a law. It's a voluntary act. So let's see, applicable to private entities is rejected. The DPPA is generally applicable to both states and private entities. Again, there's what I was telling you. Yeah, it's available to anyone on a voluntary basis. It's not mandatory, voluntary. Making resolution of that issue unnecessary. The DPPA is constitutional because Congress attempts to regulate state activity through a generally applicable measure, and the decision of the Court of Appeals is reversed. So there you go. There you have it. So the decision from the Supreme Court in 2000 supersedes Maryland, Hendricks versus Maryland case, supersedes that case. So in 2000, Judge Rehnquist made it very clear that any and all information rendered to the DMV is commerce. And the definition for commerce is business, trade. So there you go. So it's a fact, as I've told you in previous videos, anything dealing with the DMV, and I told you I would find it, anything dealing with the DMV is commercial. No state can regulate private persons' affairs. Supreme Court even said so. So there you go. Now you know. Add that to your arsenal. And for all you haters and traitors and all that, too bad. Sorry. Ain't got nothing else for you. This is Dark Angel. Deuces.